It sounds like, and I'm just shooting from the cuff here, but it sounds like you've given a lot of thought to being a judge.
I have.
Good afternoon, everybody. Welcome to Our Nevada Judges. I'm your host, Scott Coffing, here with
Ben Bateman.
and we have the pleasure to interview a judicial candidate today.
Terry Coffing, I'm running for Department 27 in the Eighth Judicial District Court.
And that's for district court, right, Terry?
Correct.
Why do you want to run for judge? Start simple.
Well, yeah, I'll be honest with you. Ever since I was a little kid, I wanted two things. Of course, I wanted to be a professional hockey player, but that ended pretty quickly. And two, I always wanted to be an attorney because I look at the career law to be one of progression. You're a student, you learn the law, you practice the law, and then it's up to you to give back either by teaching or being a judge or something similar along those lines.
And you've had quite a career. I did a little bit of research beforehand, but you've practiced here 30 plus years.
32 years.
Started as a law clerk for Jack Lehman.
I was proud to be his law clerk for the first day of drug court, which he established, and his first graduate. So learned a lot from Judge Lehman, rest his soul.
There you go. And after that, you went into?
I did a summer clerkship at what was then Marquis Arbach, and did my clerkship with the judge, and then I went back to Marquis Arbach, later Marquis Arbach Coffing, where I served as a managing partner with a full caseload for 25 plus years.
And that's quite an accomplishment to become a named partner in a firm that's already established, which is what you did, sounds like.
It was. Thank you. I appreciate that.
Yeah. So what kind of practice did you have?
I had a very diverse practice, unlike my colleagues in this race, who are very good people, by the way. Early as an attorney, well, I started in law school. I had 2 paid internships with the U.S. Attorney's Office in Minneapolis. And when I got to private practice, the firm didn't handle criminal matters, but there's always a client or someone's going to have trouble. And so I did handle a great deal of smaller criminal matters. I did 2 felony criminal trials.
What sort of trials? Just out of curiosity.
One was a robbery with a battery up in Reno,
Okay.
and the other one was an aggravated assault at a gas station altercation, both of which involved substantial prison time, as you're well aware.
Sure. Sure.
So I have this diverse experience. I won't tell you I'm a criminal expert at this point. That was a little while back in my career, but I had a very diverse civil practice. A lot of complex civil litigation, a lot of real estate matters. I have more than a dozen reported cases in state and federal courts. And that's what really made the law interesting for me, is the diversity of the clientele that I was able to attract and hopefully make happy. I'm very proud of the fact that the vast majority of my referrals came from my colleagues, other attorneys, who recognized I had a skill set that maybe they didn't, and then opposing parties who, after the dust had settled, came back and hired me as their counsel. So I'm proud of that fact.
So it sounds like you may have practiced across multiple levels. You did appellate work, you've done
Correct.
courtroom work, out of courtroom work, I would imagine, in civil practice.
Yes. Well, I'm very proud of the work I've had in the courtroom. I've argued at the Supreme Court dozens of times, Ninth Circuit twice. I'm more proud in some respects of keeping my clients out of court. It's not an efficient way to resolve disputes, and doing what you can before a dispute arises is much more valuable than it is after the fact, so to speak.
I hate to say this, but sometimes going to court's a little bit like a fist fight. There's
Correct.
going to be a winner and a loser.
That's right.
And somebody can walk away. Sometimes everybody walks away unhappy, but sometimes somebody can want to walk away really unhappy and somebody very happy, and maybe that's not where the best compromise is.
You would hope, in my experience in the civil realm, cases settle at 2 points. They settle early because hopefully they've been able to recognize the facts in the law, and you can kind of, with some experience, you can fast forward and tell where this is going to end. If they don't settle early, they tend to settle very late, and that could be as late. I've had juries in the hallway waiting for me while the case is settled. I've been 8 days into jury trials, and I get a phone call at 7 in the morning, and someone has come around on their position. And so I'd like to head some of that off. And I think with my business experience, not only running a law firm, but building a building and other things, and assisting a wide variety of businessmen in this town, business people in this town. I really want to bring some efficiency to the process. And there's so many avenues where we can be more efficient. But you can't get there without the background. You can't get there without the experience. One of my opponents, a fine person, is coming straight out of the DA's office and has no civil experience, but again, a fine person. My other opponent appears to, at least to me, have been doing insurance defense work with smaller cases, auto accidents and things. Valuable work, but not very diverse.
So the department that you're running for, 27,
27.
it's currently taxed as a civil department?
It's currently a split department, but that would likely change at the beginning of the year.
Okay. And have they said which way it's going to go at the beginning of the year? I mean, I'm assuming civil, but.
Well, it may depend on who gets elected. And so they do make efforts to try and have the courtroom fit the practitioner, the judge. So I would hope it would go civil if I were elected, but I'd be very happy managing a criminal calendar as well. So I feel comfortable in both realms, and my opponents cannot say that, it seems.
And that is a difficult aspect, I think, of Nevada law, where we have judicial elections, we have departments that don't track or specialize, which is unlike a lot of other places, other than family court, of course.
Correct.
But that makes for you don't always know the path ahead, even when you're running.
Correct.
You don't know if it's going to be civil or
Or
criminal.
it could change, it could change after 6 months, a year, it changes with personnel.
Yeah.
So, but having the experience in both realms, I mean, on the criminal side, I've done, as I said, felony trials, PCRs, some appellate work, general appellate work. I took over, and a defense attorney was unfortunately disbarred, and I took over a petition for rehearing on a death penalty case. Not a death penalty case, but a murder case. And so I have that experience, and I can certainly maintain it. I also, unique in this race, I served almost 12 years as a justice of peace pro tem, early on they threw me into the civil cases because that's where my expertise was. But I handled preliminary hearings. I signed warrants and things like that. I was also for 7 years the judge for a federally recognized Indian tribe,
Okay.
Native American tribe, and we handled everything from cases under the Indian Child Welfare Act, civil and criminal matters. It was a part-time thing, but it gave me some real perspective in my career.
Do you prefer the civil or the criminal? What's the?
My preference is civil because that's where I have the most experience, and I find I've handled some very large, very complex cases, and I've always enjoyed the chess game as a practitioner. But not being an advocate, taking that hat off and being a judge, I can see how the game is being played, and hopefully if it's being played appropriately, that's fine. But if it's not, I can spot it and hopefully bring order back to the courtroom.
How's your relationship with other practitioners?
Very well. I mean, when I came to town, as you did many years ago, it was a small bar, and you did not burn bridges. And unfortunately, some of that has changed. I used to joke, never trust anyone with a 5-digit bar number. Sorry.
That's four.
Okay, good. But you can't say that anymore. And I've had the ability and the fortunate to practice in other states. Like I've tried cases in California on several occasions, and their attorneys never see the same counsel again. And so it's many times just this scorched earth, hide the ball, argue, fight about things that need not be fought about. And I was fortunate to work in this town at a time when that wasn't that way. And as a judge, I would try to bring that back to the courtroom. I've always thought I would be the first to comment if I have litigants in front of me. I'm going to tell them if I don't like the rhetoric in their briefs. I'm going to tell them that, and they're going to abide by it, and it's going to change because it's just not warranted. We need to bring some of that civility back. And unlike some of my colleagues, I believe civility in the courtroom starts with the judge. I need to be civil to them, but I need to enforce civility in the courtroom. And so I think there's lots of ways you can do that and make it efficient. You make it clear what your thoughts are. I got a rhetoric meter, and you're getting into the red, and you need to stop that. And here's a statement. You want to say this to your opponent's face, because oftentimes they won't. People will put in writing what they will not say in person. And to me, that doesn't need to be. And I think bringing efficiency into the equation by issuing tentative decisions. In many other jurisdictions, you get the day before your hearing, you're going to get either a decision or a tentative. A decision saying, I've read your pleadings and briefs. I think I'm comfortable. I don't need oral argument. Here's my decision. You want to show up and argue, you think I've missed a point? You can. But other than that, you submit an order and we'll move forward. Saves their clients a ton of money. Or that tentative, if it's not complete, I need you to focus on this issue, this issue, this issue. And that way, when they come into court, they're prepared and they know which way or how I'm thinking and what they need to address, rather than rehashing what they already put in their pleading.
And that's all very practical, although I think some of the times clients pay for dog and pony shows when maybe they ought not.
I'm not going to, I certainly wouldn't say I want lawyers to be lawyers.
Yeah.
And sometimes, I'm a legal nerd, sometimes it's a joy to listen to some compelling legal arguments by fine advocates. And those are the cases where you maybe a tentative decision wouldn't be appropriate because they are complex and you do need to hear some additional facts. But so much motion practice, it seems to me, can be resolved short of getting to that. The other thing I'd make more efficient is I have a goal. I spend a lot of time in business court, and the goal in business court is a year from complaint to disposition. I want to bring that to all aspects of the court. I want that 1 year time frame should be enough if you're moving things along like a good judge does to get that case there, rather than the 2 to 4 years now it takes to get to trial.
And I have to mention the exception that proves the rule, but there are some criminal cases that just, I don't believe are capable of being prepared that way. Capital cases is an example. You have to do mitigation and those sort of things, and it takes years sometimes. That's my bailiwick.
And criminal needs to take priority. If somebody's liberty is at stake, if they're in custody, that needs to take some priority over the dispute over a boundary line, So I recognize that, and I would, certainly not rush to judgment or disposition of a criminal case because of that very fact.
It sounds like, and I'm just shooting from the cuff here, but it sounds like you've given a lot of thought to being a judge.
I have.
And it sounds like consistency. I know my mentor or guru was a gentleman named Donald Mosley.
Oh, yes.
Who wasn't the best of criminal practitioners as far as results and things, but he was consistent to a fault. I knew exactly where he was going to go and what he was going to do, and I didn't worry about him waking up on the wrong side of the bed and doing something out of character to a defendant one way or the other. And it made practice a lot simpler because I knew what to be able to tell my people. What role does consistency play in this whole thing for you?
I think there's two aspects to consistency, and that's the first one. Consistency speaks for itself. You need to rule on the law and the facts as they are presented, and if you get the same law and the same facts, you need to rule similarly unless there's some real big mitigating or aggravating factor. But the other part of consistency in my mind is decisiveness. I'm going to decide. No decision is worse than a bad decision. If I make a decision and it's wrong, there's some people up in Carson City you can go talk to, all right? And that's the way the process works, but I don't want to have you linger on. I've got this under advisement for the next three months, or I don't think I can rule on that now. I go back and do more discovery. Unless it's something very pointed, I need to answer this question. I want to bring that decisiveness, which creates the consistency, and the efficiency.
Yeah. One of the things I was curious is that you said you'd had experiences of pro tem and of the Indian tribe. And so, what did you learn? We all know, every lawyer knows what a judge does until they actually sit as a judge. So, what did you learn from that you're like, man, I didn't realize that this was part of the job of being a judge?
Well,
And sort of maybe also something on the similar lines of what's kind of how would you describe your judicial philosophy or your role as the judge? Kind of what did you learn and how do you see yourself?
What I learned, especially early on in my career being a law clerk, where we had a civil calendar, a domestic calendar, and a criminal calendar, because we only had 3 hearing masters back then. The person that can most impact, the elected official that is most likely to impact your life, wears a robe. You're either going to have a domestic matter, God forbid a criminal matter, or you're going to have a civil dispute. So my philosophy is, number one, to try and bring some understanding of the problem, conveying that understanding consistent with the law, and making that decision. So my philosophy would be knowing the law, applying the law, and making the ultimate decision. And I learned a lot about that, especially working for the tribe, where we had some very hard cases under the Indian Child Welfare Act, very difficult facts, very tough rulings to be made. And then there were some that were relatively easy. We had a consistent criminal element, very small element, but we had a very consistent criminal element on the involved with the tribe, and on occasion the FBI would be involved, and I'd sign warrants for them and do things like that. So that's, having that experience, I think, is so valuable.
Mm-hmm.
The other thing that I want to mention that I don't think my opponents can say is I've given back a lot. I've done hundreds of hours of pro bono work, and I worked it out with legal aid a little bit. Say, I'm not a good child advocate, but you've got a complicated case that needs someone with some specialized experience. One of my last pro bono cases, I ended up in a TRO hearing in federal court. And, I'm very proud of that, giving that back. And I've got a reported case that came to me as a pro bono case. And I've given back to the bar as a whole. For the last 6 years, I've been a member of the Nevada State Bar Board of Governors. That's taught me a little bit about how we really need to think about our practice beyond the day-to-day. What are we doing as a bar to protect the public, to police our members who sometimes get out of line? What are we doing there? And it's really given me some good perspective along those lines as well. And that's all, as you know, volunteer time away from my family, but I think it's been time well spent. I've learned a lot.
Yeah, any sort of cases that would be too big, too complicated, too difficult, whatever it might be. I mean, you've done a lot in your prior practice.
There's certain things that I would not do, and I've learned that in the last 3 years being in-house counsel for a tech company. I would not take on an intellectual property case. I wouldn't do it. And first of all, it wouldn't come to our courts, so they'd be in federal courts, so I'm safe there. But I've handled some really big cases. I've been fortunate enough to represent some famous people, boxers, Johnny Tapia, UFC, Wanderlei Silva, and some politicians. I believe I've also had a subspecialty with defamation type thing. I think I've represented every media outlet in this town on something, quietly mostly, and I'm proud of that work as well. But if you're asking me what cases could come before me in this court, I'm not afraid of anything at this point. I'm really not. But knowing what you don't know just is something that comes with age, I think. Mm-hmm. And then knowing how to find out the solution to something you don't know.
So our independent judges has done a tremendous job of getting
Great
cameras in the courtroom where the public can see what's going on a day-to-day basis. What's your thoughts on that, just out of curiosity?
2 things. Number one, I think this is a great organization. I tried something similar back in 2018. I formed an organization called Edjudicate, where we did interviews with pending candidates. And it's something I did on my own, funded, and I set up the website, and I think we provided some valuable information. So I like what you've done here. The second part of that, it really, we need to have the public more aware of who they're electing, just because of how important these jobs are. And that's why I really appreciate the efforts and the time you take to do these kind of things. As far as cases that would come before me, I'm very proud of some of the cases that I've tried. I've tried the Thitchner versus Countrywide case to the jury and to the Nevada Supreme Court. That's still the seminal case on punitive damages in the state. I tried a very unpopular case on behalf of the at the state and Supreme Court level, very unpopular on behalf of the Southern Nevada Health District, the smoking ban case, bent barrel, and so I'm familiar with the large cases. I'm familiar with the complexities. It wasn't unusual for me to be one of 8 attorneys, in the room on a side. I'd like to try to minimize that. I think, again, being efficient, I don't need to hear from 4 attorneys about the same issue. You got designate 2 on each side. Let me hear from them. I don't know if I want your younger people to get that experience, but I can't leave a courtroom full of other attorneys billing their clients while we spend an hour on a motion.
Thank you so much for coming out
Thank
for
you.
us today. I want to make sure you have the last word because you are running for office, and it is a important office.
Great. Thank you. Again, thank you for this opportunity. Thank you for the service you provide. My name is Terry Coffing. I'm running for Department 27 in the 8th Judicial District Court. I'm unique in this race in that I'm the only attorney in this race that has both extensive civil and criminal experience. And I believe my history as a judge in other forums will be valuable, as well as more than 30 years of practicing in this jurisdiction. And I'd like to ask for your vote. Thank you.